Are we live? Okay. Do we get visual at all? Okay. So good afternoon, Your Excellency Art Biesebrock. You are the ambassador of the delegation of the European Union to Trinidad and Tobago. I am formally reconvening the Special Select Committee meeting set up to examine the Income Tax Amendment Bill 2018 and to report back to the Parliament. We have a very tight deadline. Report back to the Parliament on Friday of this week. This hearing is being broadcast live on the Parliament Channel 11 and on the Parliament Radio 105.5 FM and the Parliament's YouTube channel, ParlView. May I introduce the members of the committee? Mr. Fitzgerald Hines, MP, member. Mr. Faris Al-Rawi, MP, member. Myself as Chairman, Colum Imbert, MP. And Mr. Randall Mitchell, MP, member. Have you, Ambassador, been able to look at the legislation in terms of what we are seeking to achieve?
Thank you, Honourable Minister. Yes, indeed, I received the piece of legislation. I have read through it. I need to say that on the technical merits of the piece of legislation, I would have to consult with the Code of Conduct Group or DG Taxud of the European Commission to assess the details. The technical merits, it's up to the Code of Conduct Group to assess.
You want to lead off?
Yes, please. Welcome, Excellency, to this Special Select Committee. Before us is an exercise of consultation and addressing some of the issues that our country wants some clarification on as we perceive it. May I just ask, perhaps by way of question and answer, that we proceed along a path of just leading some information. Maybe easier if I were to ask you the direct questions and ask you to respond to the issues. So, Ambassador, are you aware that the Global Forum has been in a working session with Trinidad and Tobago?
I have not been formally informed of the matter, but I understand that this is work in progress. But I am not privy of the details of the discussions that have been taking place recently.
Of course. Would you assist us by leading us through the process of compliance from your perspective as the ambassador for the European Union in identifying what you need us to be aware of in terms of process steps to treat with compliance issues? Perhaps you may wish to explain what compliance is required and what the steps along that way include.
Yes, Honourable Minister. For the European Union sorry, maybe it's my phone.
Problem is, there's some feedback. Sorry.
The European Union has been corresponding with the government of Trinidad and Tobago since mid-2017, I would think, directly with the Ministry of Finance, with the Minister at a certain point in time. They've also been engaging with the Embassy of Trinidad and Tobago in Brussels to discuss the criteria for compliance under the EU. The European Union had identified a number of criteria that in the process Trinidad and Tobago had committed to comply with. In the most recent exchange of correspondence, the EU, the Code of Conduct Group, which is, by the way, a group of the member states of the European Union, it's not the institutions, but it's the member states that follow this process, had identified 3 remaining criteria that needed to be addressed. And I think the first one is to become largely compliant with the requirements of the OECD Global Forum on Transparency and Tax Exchange. The second criterion that was identified was to sign a multi-national agreement on automatic exchange of tax information. And the third criterion would be the elimination of harmful tax practices.
Thank you, Ambassador. Could you please assist us in explaining the manner in which this approach is intended to happen? Is it something that can be done? Is it something that is done in a phased operational step, or is it something that is done in one fell swoop?
The situation is that Trinidad and Tobago was listed in December 2017 as non-compliant. And the process is that the country can be delisted, provided that the country makes a sufficient progress in meeting the requirements to become compliant. And as I mentioned, the three elements that are being discussed are precisely to become largely compliant with the Global Forum and the two other remaining elements, which is the signatory of the multinational agreement on tax exchange and harmful tax practices.
Ambassador, thank you. In describing it that we must make progress, could you please inform as to how often that progress is monitored and where it is monitored and by whom?
Yes, well, the progress is monitored on a regular basis. So in as far as the European Union is concerned, there are no specific deadlines that are set because you are already listed. So the question is that the moment Trinidad and Tobago thinks it has made sufficient progress and can meet the additional requirements, is committed to meet the additional requirements, they can request the Code of Conduct Group, which is again the member states at the Council of the European Union, to proceed with delistment. And then the Code of Conduct Group will then assess the proposals, the progress that is made, and the commitments that will be made on its technical merits.
So, Ambassador, the Code of Conduct Group looks at the progress of countries, and in our case, Trinidad and Tobago, as it relates to two entities, as far as I am aware. One is the progress that you've made on the Global Forum track, which is not what the European Union itself in the Code of Conduct does. The Code of Conduct observes what the Global Forum process is in another arena, and it also observes the process of countries, and Trinidad and Tobago specifically, in the FATF progression. Are you aware, and can you speak to the particulars of how progress moves in either Global Forum or FATF, or is that something outside of your purview?
For the review of for tax purposes, for the non-cooperative tax jurisdictions, the process is I outlined. The moment you feel you have made sufficient progress and you are ready to make additional commitments in order to meet the requirements that the European Union has identified, the EU, the Code of Conduct Group, is ready to assess the proposals.
Does the EU take notice of the publications made by the Global Forum and the FATF?
Clearly, those are elements that are taken into account when the EU is making the assessments.
Are you aware that the plenary sessions for the Global Forum and for the FATF happen on periodical bases?
Yes, I'm aware of that.
Are you aware that the Global Forum plenary session for consideration of Trinidad and Tobago's issue was held in Uruguay on the 20th to 22nd of November?
I was not aware of that, but I understand that indeed took place, yes.
Are you aware that the FATF, the Financial Action Task Force, held its plenary session in October of 2018?
No, I'm not aware of the proceedings of the FATF at this particular point in time. Yeah.
Could you tell us whether Trinidad and Tobago has been listed negatively, blacklisted, on the basis of having appeared on the FATF, the Financial Action Task Force, ICRG publication. That is the International Cooperation Review Group of the Financial Action Task Force. Are you aware, and can you tell us whether the European Union has blacklisted Trinidad and Tobago on the basis that it has appeared on that document published?
Trinidad and Tobago was listed on a list of countries that were considered high risk with regard to money laundering and terrorism financing. That is indeed the case, and that was done based on the findings of the FATF that were published at the time. Correct.
Thank you. So you have thankfully confirmed that we were listed on the back of the publications by the FATF.
Yes, at the time, and there were discussions in the European Parliament, the situation was that this was what they call a delegated authority, delegated power of the European Commission to follow the outcome of the proceedings of the FATF. What they're doing now is they are installing their own assessment procedure, looking at the FATF requirements, but also looking at some additional elements.
So is it true to say then that the European Union, the Council of Europe, takes steps independent of international organizations such as the Global Forum and the FATF, and it does so on the basis of publications coming from those entities, amongst other things?
That is correct, but they will make the additional assessment of the situation.
Are you aware if Trinidad and Tobago wrote to the European Parliament indicating its position on the blacklisting by the Council of Europe?
I have not seen that correspondence.
Okay, well, I can inform you that Ambassador Connolly in fact presented a statement to the European Parliament and to the Council indicating Trinidad and Tobago's position that it was in high-level commitment and compliance to working its process out, and that it asked the European Parliament to take notice of the fact that Trinidad and Tobago was working on its progress. So I just wanted to get those parameters from you, so I'm just giving you that information. Could I ask you a few further questions? You spoke about 3 criterion that the Code of Conduct Group looks at. Becoming largely compliant with the OECD Global Forum and tax transparency measures. Secondly, signing on to the multinational agreement, multilateral agreements. And thirdly, making sure that there was an elimination of harmful tax practices. Could you assist me in identifying, with respect to each of these, well, let me put it to you this way. Are you aware as to whether Trinidad and Tobago has in fact signed any treaties with other countries that would comply with the tax exchange information aspects?
No, I'm not aware of that. I've not been given additional information about progress that was made since the early exchange of correspondence that ended with a letter that was sent by the Code of Conduct Group to the Honorable Minister in February 2018.
Would it be correct to say that the correct entity to speak to that would be the Global Forum?
Well, I think there are parallel processes. I think it's very important indeed to speak with the Global Forum. As I mentioned, one of the criteria is that for the European Union is for Trinidad and Tobago to become largely compliant with the Global Forum. So that is indeed correct. But in addition, there's the parallel process or the subsequent process of the assessment that takes place by the European Union, where they also look at some of the additional criteria. And that's the Code of Conduct Group that is assessing progress, commitments, and measures adopted. So I think it's important also that Trinidad and Tobago engages with the Code of Conduct Group in that regard.
With respect to the elimination of harmful tax practices as one of the 3 issues, could you assist in explaining what that refers to? Is it reference to the base erosion and harmful tax practices, what people commonly refer to as the BEPS issue?
I understand that to be the case, and there was an element of a free zone treatment, which is probably linked to the BEPS situation.
Yes.
Yes.
And with respect to tax transparency, which is in the first issue in Trinidad and Tobago needing to become largely compliant with tax transparency, does the European Union have a point of view as to what tax transparency is?
Yes, the European Union has a clear idea, I think, about what tax transparency is, yes.
Is that the elimination of secrecy provisions?
That I do not know. I'm not a technician dealing with the technical elements of the tax exchange information criteria. I think the detailed questions need to be discussed with the Code of Conduct group, which is composed of the financial attachés of the member states and colleagues from the European Commission who are working in the Directorate General for Taxation.
Let me come in here. Ambassador, if Trinidad and Tobago continues to be non-compliant or continues to be on the list of non-cooperative jurisdictions for tax purposes, what are the repercussions of that?
Well, if you look at the Council conclusions that were adopted in December 2017, a number of defensive measures have been specified, and some relate to defensive measures in non-tax area, which are linked to the use of the European Fund for Sustainable Development. But they're also looking at defensive measures in tax area. And the member states agreed, the Council agreed, to ensure coordinated action, the member states should apply at least one of the following administrative measures in tax area. Reinforced monitoring of certain transactions, increased audit risks for taxpayers benefiting from the regimes at stake, increased audit risks for taxpayers using structures or arrangements involving these jurisdictions. And then without prejudice to these measures that could be taken in the spheres of competence of the member states, additional measures, defensive measures of legislative nature in tax area could be applied by the member states. And they list a number: non-deductibility of costs, controlled foreign company rules, withholding tax measures, limitation of participation exemption, switchover rule, reversal of the burden of proof, special documentation requirements, and mandatory disclosure by tax intermediaries of specific tax schemes with respect to cross-border arrangements. So there's a number of measures that the member states could adopt if they choose to do so. In addition, they are expected to adopt one of the three measures that I mentioned at the beginning.
Would you describe those repercussions as serious?
I think over time they could become serious, because I think they could increase the cost of doing business.
Would it lead to the loss of correspondent banking, de-risking, and so on?
That might eventually be one of the consequences. Yeah.
Microphone.
Your responsibility in Trinidad and Tobago is to increase trade with the European Union.
Correct.
How would this delisting or de-risking affect our relationship with the European Union, in particular as it relates to trade?
Well, I think delisting would certainly be helpful, because it would facilitate financial transactions and avoid any of the defensive measures that I mentioned. So that would be beneficial for the trade relationship. Not adopting the measures may make it more difficult for businesses to do, for enterprises rather, to do business with Europe, or make it more difficult for the banking sector to do business.
Wouldn't it be true to say, Your Excellency, that if Trinidad and Tobago remained non-compliant and did not demonstrate progression in taking itself out of non-compliance, that the banking sector in the European basin would have extreme difficulties in conducting any transactions with us? How does one conduct a transaction under a blacklist and enhanced due diligence?
Well, I don't think that if you look at the measures that are being requested, the idea is to stop the transactions. but they ask for more due diligence, more audits. So basically it becomes more work for the bank to carry out the transactions, because they needed to provide the guarantees that they
Allow me to
do
come
proper
in here.
transactions.
There was a parallel problem in the United States when we were moving towards becoming compliant with their FATCA legislation, where banks, American banks and American financial institutions just decided it wasn't worth the trouble doing business with Trinidad and Tobago because of the increased due diligence, the increased compliance requirements became expensive, became tedious and difficult for them, and they just stopped doing business with Trinidad citizens and Trinidad banks. Because of this increased burden that comes on financial institutions in the EU as a result of us being on this list of non-cooperative jurisdictions, do you see that being a possibility, that European banks will say, look, this is too much trouble, this is too much due diligence, I can't be bothered, I will go and do business with China, or well, maybe that's a bad example, but some other country?
Well, I think it would be very difficult for me to speculate about the reasonings that the banks would make, and I think the banking sector probably here in Trinidad and Tobago would be better placed to provide that feedback. I don't know. It is clear that they are required to do additional checks and balances audits. So clearly that makes the business more difficult.
Sorry, Minister Mitchell. Yeah.
So the EU and their position in the global forum, they're very interested in the free exchange of tax information and transparency as it relates to tax. In particular, the tax avoidance and tax evasion problem. Why is that so important to the EU? And why is that so important worldwide now to treat with that problem?
Yeah. Well, I think you mentioned it's not just important for Europe, it's important for any country to ensure that its citizens, its taxpayers, indeed declare their income and pay the right amount of taxes over their income. And I think, as the Panama Papers have shown, it does not always happen. So the better transparency exists and the better countries exchange information with each other over the income that citizens of the other country may have collected in the country concerned, the better it is, because it ensures that taxes are paid where they are due.
So for a small jurisdiction like ours, I mean, you've been here for some time now, where we would have experienced a sharp decline in oil revenues, is it your opinion that it would be a tremendous benefit for our jurisdiction, our government, our tax collection agencies, if we were to also have that agreement for the exchange of information with tax information with other jurisdictions in terms of persons who may be avoiding or evading taxes here in our jurisdiction?
Yes, right. Indeed.
Ambassador, just further question from me. Does the European Union have any form of assistance in terms of jurisdictions that remain in this non-compliant state? Are there any programs that the European Union is engaged in currently or intends to engage in this regard?
Yes. Well, first of all, we try to engage with the countries concerned. There was a workshop that was organized here in Trinidad and Tobago a number of months ago, together with the other Caribbean countries, to explain the process to the ministries of finance of the different Caribbean countries. CARICOM has recently agreed on a program to be financed under the European Development Fund, managed by our regional delegation in Barbados, that will provide, or that can provide, assistance to the countries that would want or that would need support in order to become compliant. So yes, that program is coming up. I think the decision was taken recently. And in addition to that, we are open to look at needs on an ad hoc basis where they are formulated by the countries concerned. So whenever Trinidad and Tobago has a specific need in becoming compliant in one of the other areas, we're happy to look at that.
Very much, Your Excellency. I think that will be sufficient for the day. And thank you very much for attending this live hearing on this income tax amendment bill. And we welcome your offer of assistance. Okay. Thank you.
Thank you very much.
Everybody here? Good afternoon. I understand you are the representatives of the Bankers Association,
Yes,
legal and compliance,
yes.
among other things. I was so told by the president this morning. We had a discussion about something else. This is of the Bankers Association. We are live. This is, yes, we are live on the Parliament channel, channel 11, and the Parliament radio station 105.5, and the Parliament YouTube channel. Perhaps you may wish to introduce yourself and identify a leader of the team.
Okay, well, I will introduce the team. Republic Bank is the sitting president of BAT, and therefore a lot of the chairpersons of the different subcommittees are Republic Bank representatives. So we have Charlotte Belmar, she's the chair of the Compliance Committee. We have Baldat Ramkizun, he's the chair of the Foreign Exchange Committee. Joel Chadha, the chair of the Legal Committee, and Suzanne Williams, she's also on the Compliance Committee. And I'm actually not on the BAT committee, but I'm with Republic and also representing the chamber, which I guess we'll speak on later.
Very much. And in our committee, we have Mr. Fitzgerald Hines, MP, member, Mr. Faris Al-Rawi, MP member, myself, Colin Membert, member, and Mr. Randall Mitchell, MP, member. We've just completed an interview with the European Commission delegate, and now we have the Bankers Association. I'd like to go straight into it. What would happen if we are unable to pass this income tax amendment bill? Could you try and put it into layman's language so people will understand what would happen?
Thank you, Chair. De-risking is a phenomenon that has been engaging our attention for several years. The Caribbean region has been a region classified as one of high risk for various reasons, and as a result of that, the region has been prone to the phenomenon of de-risking by correspondent banks. In simple terms, what it really means is that the range of products and services that are offered to a bank in, for instance, in Trinidad and Tobago, really become, the banks become precluded from that. So, for instance, if you think of a business sending out a wire to settle with their supplier, or, for instance, foreign cash notes, these are services that are provided by correspondent banks. Businesses, for instance, for trade purposes, will require, for instance, the traditional trade financing instruments, letters of credit, standby letters of credit. The banks themselves, for instance, for foreign currency funding, can tap into correspondent bank lines for funding for various reasons. So these are an idea of some of the range of products and services that correspondent banks provide to respondent banks like ourselves. We do need correspondent banking partners because we don't have physical operations in jurisdictions outside of Trinidad and Tobago to make the financial services available. We therefore need partners. If therefore we do not have these financial partners and the correspondent banks, it therefore means that these are services and products that are no longer going to be available. And it will therefore really have a very negative impact for banks to be able to execute and to provide the type of services that are required for us. And that has wide-ranging consequences, including at a national level, the ability to really pin down or impact negatively on the country's wealth or gross domestic product.
Perhaps your chair of legal, Mr. Chadha, and welcome to you all, could give us some perspective on the legislation. Have you had a view of this income tax amendment bill? If so, what is your view? Do you have concerns in relation to the bill?
Hi, good afternoon, everyone. We have had a preliminary look at the last draft that was circulated. I think, you know, from where we are sitting at the end of the day, this is something that has to be sorted for the reasons just mentioned. In terms of the actual legislation, I don't think we're that far away. And I understand there are concerns on both sides with what the opposition has presented and what yourselves have put forward. I actually think, you know, we are down to a couple of specific areas which has been circulated to the wider party, and at least from where we are sitting, we think this is something that can be agreed on fairly quickly. I mean, I don't see any particular obstruction to getting this done in an expeditious manner.
Thank you. So let's dive to the issue directly. What is the issue? So the bill is 10 clauses long. Could you assist us in, because we've been trying to get to the crux of what is in fact an issue as a committee and certainly as a parliament. What does the Bankers Association and in particular the legal committee view as being an issue, and what is the potential prescription to solve that?
I mean, I think a lot of it came down to the secrecy of one's tax affairs. I think that was in the response provided recently. I think that was, from our perspective, that was addressed where the amendment was made.
Speaking about the sharing of tax information with these other jurisdictions.
Correct.
And we have to get around the current secrecy provision in the Income Tax Act to allow the sharing of tax information.
That's correct. Okay.
Perhaps I could ask a few questions, maybe to be a little bit more pointed. What is the bank's position in relation to the sharing of tax information with foreign jurisdictions, other tax entities, competent authorities in other jurisdictions? What's the bank's position, the banker's position in relation to that?
Once there's legislative reform to provide for that, we don't have an issue, as was the case with FATCA.
Right.
Remember, that was one of the biggest issues.
So you approve of the FATCA approach for the reciprocal exchange of information, tax-paying information between competent authorities?
Absolutely.
Great.
Yes.
Secondly, what is the banker's view in relation to the international requirements that say from FATF, Financial Action Task Force, and Global Forum that you must dismantle your secrecy provisions to allow for that exchange?
We're in support of that, especially with regards to the new provisions which were put forward, whereby, if, for example, it was done by way of a High Court order, then we have no issue in such a regard.
You're referring to the judicial oversight. Correct. When a police officer would seek to get access to tax information. No problem. What I would like, and you're in support of that, judicial oversight. What I'd like you all to do for us, could you give us some examples of transactions that may no longer be possible? And let me just throw out some. You spoke about wire transfers. This would be to pay for goods and materials and so on. This may no longer be possible. What about credit cards? Could it affect credit cards?
Absolutely.
So your credit cards may no longer be valid.
Well, there's a whole suite of products that the correspondent banks
let's hear. I think the public,
so I'm just going to pass
the reason why we're having a live hearing, we want the public to know what will happen to them if this legislation is not passed.
Sure. And perhaps maybe what I can do is start at the beginning, really, of a working capital cycle. A business needs to order for material. Their international supplier wishes to have some guaranteed form of payments, and therefore your standard letter of credit, a confirmed letter of credit is required. This will be, for instance, one example of a product that will no longer be available because it's the international bank that really provides these guarantees. So the business is impacted right away in terms of the access for capital. Let's say we get past that hurdle. Now the business has exported, and the business or the local manufacturer has to actually be repaid.
Want to get paid.
Yes.
Right.
The wire that is supposed to be coming into his account will be impacted because you don't have a correspondent banking relationship.
Can't get paid.
Correct.
Right.
And of course, that will have a very negative impact. Credit cards are also an example because when we think of it, behind the background in a credit card, you really have banks that are settling, including our correspondent banks. And of course, if we don't have the privilege of the services of our correspondent banks, then really the ability to settle on your credit card also becomes impacted. For the travel period, we all need to have some cash in our hands for safety, etc., for tipping, etc. Cash notes are a service that are provided by correspondent banks. And of course,
I would like you to clarify that. A lot of people don't know that foreign banks provide US dollar cash notes to local banks through correspondent banks. I don't think there's any appreciation of where US dollar currency comes from. You know, there is a view that it's in some cupboard somewhere and you take it out. But it is not so. It is provided to the local banks by foreign banks. Could you elaborate on that, please?
Indeed, Chairman. Yes, so it is actually a product of correspondent banks, and not all correspondent banks are permitted to provide this actual product. So there's really, in this region, really a very limited offering of this product from a correspondent bank. And I'll share with you, it was actually in the public domain when a correspondent bank actually de-risked in Guyana a couple of years ago. And therefore, the Central Bank of Guyana no longer had access to cash note services. So, yes, it is a product, and really your shipment of cash notes do tend to come in from a correspondent bank, and therefore the availability of foreign currency cash notes, and these cash notes are normally the hard currency, including EC dollars, Canadian dollars, sterling, the normal destinations that a citizen will travel to and require cash notes for those jurisdictions. Those are brought in from our correspondent bank. So those are some examples of the type of products. And of course,
Great.
sorry, excuse.
I'd like to kind of move on to another point. What do you see in this legislation that is not safe or a risk to citizens? What's the danger to citizens of this legislation from the perspective of the bankers?
From the perspective of the bank, I mean, from what we see, the model is pretty much similar to what we've had with FATCA. There are layers, there are protection. So really, there's hardly anything, I would say perhaps we really see nothing in there that is really debilitating or prohibited.
You were going to say something?
I was just really expanding, but I think there's a good sense of the offerings of the products.
So you see nothing in this bill that is any different from what has been done before with FATCA and so on, and the safeguards are there.
Indeed, and what I can also share with the committee as well is that we constantly engage with our correspondent banks, and our correspondent banks are very, very keen, really, in having the legislation and the oversight, etc., in place. So they're actively monitoring it. As recent as this week, one of our correspondent banks came in, and that really was the opening matter that came up. You know, and so they are following the progress.
Are you aware if any corresponding banks have suspended services or cautioned in a way of an actual stop?
Not at this point in time. I believe.
Actually heard of two.
Yes, that
I heard of an American bank that has actually decided to no longer provide services, and I heard of a Chinese bank that is a bit concerned. Perhaps your colleague could.
And just to assist on the same point, I was actually informed by the president of BAT that there have been losses of relationships. Can you confirm whether that's in fact correct?
Velma, yeah. Good afternoon, everyone. I don't think there have been complete losses of relationships. What we've been seeing is a more intense scrutiny of our operations and our transactions. And what the correspondent banks have been doing is basically reducing or eliminating some of the services that they would be offering. And that is I guess, the beginning of the impact that we're seeing. So in some cases, as Baldat mentioned, they would have removed the cash services. What we also may have seen, not with Republic Bank specifically, would be removal of cash letter services, which is basically where they would encash foreign checks that are deposited because of the risk associated with that. So we are seeing, and from a compliance perspective, we are seeing a lot more scrutiny from our correspondent banks. Now it's very routine that they would perform KYC on us biannually or once or twice a year. The questioning is becoming
Know your customer, KYC. Sorry.
Sorry.
There are a lot of people that don't speak acronyms.
I'm so sorry. KYC, know your customer. The know your customer questionnaire of the banks has become quite in-depth and very detailed, so that we've been required to give additional information. We are seeing the intensity, that intensity happening from the correspondent banks, and it tells us that they're scrutinizing us a lot more closely.
A previous chairman of BAT, Anya Schnoor, in talking about FATCA, had used an expression which I find very helpful, and I'd like your view. She described the failure to implement FATCA as death by 1,000 cuts. Is this what you're referring to?
Well, I guess we can put it into those terms, yes. A slow and painful death.
Can I ask you a question as a regional group? Sure.
I got the impression that other members of the team wanted to say something on this matter.
No, it was just to support what Charlotte was just relaying. While there hasn't been a complete termination or suspension of services, you are seeing certain products withdrawn from the local market by some of the correspondents.
Yes, AG.
As a regional group, and in particular wearing your hat as Republic bankers, now having a larger footprint in the Caribbean, how do you match up jurisdictions like Barbados, Bahamas, Cayman, all of whom have dismantled their secrecy provisions in law, with what Trinidad and Tobago is faced with now? How does that affect your profitability and your intra-banking as a group, having now acquired banks in other territories?
Well, I mean, having acquired or being in the process
of acquiring. That's why he's speaking
I can tell you there's
in a particular way.
Enhanced due diligence, especially on the regulatory side. And from the feedback I got from the other members of the legal committee, whose organizations are not necessarily in the process of doing an acquisition, etc., they are also feeling the brunt of the enhanced due diligence from regulators. So from the regulatory standpoint, there is definitely an uptake in the level and the amount of inquiries coming from the regulators.
The question, I mean, it's a speculative question. You don't have to answer if you can't. If we don't pass this legislation, how soon will we begin to feel the pain of not being able to wire transfer, pay for goods, receive payment for goods, use the credit cards, etc., etc.?
Okay. Rather than be speculative on the time frame, maybe it could be 18 to 24 months, what I'd really like to point out is for the Republic Financial Holdings Group, where 70% of our revenue really is from the Trinidad market space, what we have seen in the past is that when some jurisdictions in which we operate in, for example, Suriname and Guyana, when Guyana was blacklisted, and when we entered Suriname about 3 years ago, and they had lost correspondent banking relationships when it was under the old RBC, the strength of continuing to provide banking services in those jurisdictions really stemmed from Trinidad. Because our parent company of the group was in Trinidad, our correspondent banks were able to still serve those jurisdictions because the strength of Trinidad and the parent company relationship stemming from Trinidad. So for Trinidad to be affected and our parent company to be affected would have significant impact on the rest of the jurisdictions in which we operate. And that's critical.
Do you have any questions?
Chairman, just for the benefit of the ordinary citizen who would interface, who has enjoyed your services, your clients, what exactly do you mean by correspondent banking relationships, and what do you mean by enhanced due diligence?
So correspondent banking relationships are really relationships with foreign banks where they offer you, to put it in very simple terms, they offer you an account in a foreign currency. So for example, Republic Bank, we would have accounts with banks in the US, and those are basically set up to facilitate our customers. So you can have an account with a US bank, but when you have an account with Republic Bank, a US account, that account is really hosted at a US bank. We have accounts in many currencies to facilitate trade, as you know, with many jurisdictions and with different continents, so that our relationships, span maybe about 40 banks internationally in terms of different currencies, and that is basically what correspondent banking is. When you have
If I could put it into layman's language as I understand it. Let's say a Trinidad and Tobago citizen, a parent, has a child studying at the University of Kansas, and they want to do a wire to pay tuition fees. You would not have a correspondent bank in Kansas. You might have it in New York or Los Angeles or something like that. So in order to send that money to the school in Kansas, it has to go through the correspondent bank in New York or Los Angeles.
Right.
And if you don't have a bank to pass through, it will never get to Kansas.
That's correct.
Is that
right.
it?
That's very
Okay.
correct, yeah. So to get to anywhere in the US, to get to anywhere in Europe, for example, if we have an account with Barclays, I'm just calling, hypothetically, Barclays in London, or if we had an account with Royal Bank of Scotland for a euro account, that would facilitate our transactions in France, in Spain, in any of the European Union countries.
That relationship with the Barclays in London,
it's-
hypothetically, it'd be very difficult.
It's very basic. If we lost any of the relationships, we cannot conduct any transactions in those currencies.
And that means citizens in
Citizens
Trinidad and Tobago
cannot.
will not be able to conduct those transactions.
And even much more far-reaching impact in terms of our imports,
Yes.
availability of products on the local market.
Food.
Food. Our import bill for food is very high. It means that we would be very limited in terms of what is available on the local market.
Fines? Yeah.
The question of enhanced due diligence, what does that mean to the ordinary man?
Well, the legislation provides a bare minimum amount of due diligence that has to be conducted both on a customer and a transaction. Enhanced due diligence for a transaction could mean the provision of extra documentation. So, for example, if there's a wire, there's extra scrutiny. You start to look at patterns of funds, etc. The persons involved, both the receiving party, the sending party, because quite often there's numerous parties involved. So, what all that actually results in is both a extra cost and time. It could be notarized documents being sought from the customers, etc. There's a time impact in having to assess and evaluate all the documentation provided. When we do business with a so-called high-risk country, we also go through that process of asking for enhanced due diligence on both the customer and the transaction as a whole. So in the event that, we were to either remain on this blacklist or, God forbid, correspondent banking relationships, become more tenuous, then we will have to face that enhanced due diligence on, I would say, it'll become a part of the course.
Sorry, I just wanted to add to what Joel is saying, and in addition to that, also increases, even if we were to maintain our correspondent relationships, the cost of doing business. can be impacted, where we would now be required to pay higher fees. Transactions, they would be increasing the fees on the respondent banks, which in turn would impact our customers in terms of wires, drafts, whatever the service might be.
What I've learned with respect to this problem is that some foreign banks just decide it isn't worth the trouble to do business with a bank in Trinidad because of the cost and the tedious nature of all the paperwork and the due diligence and so on. Is that correct to say?
That is correct. For the correspondent banks, the Caribbean represents a high volume, low profit income.
So already,
and a lot of banks are making that decision. Is it the risk? And then the risk associated with the Caribbean.
Yeah.
Is it worth the risk of maintaining relations in the Caribbean for low profitability?
Nickel and dime stuff.
Yeah.
Yeah. Mr. Mitchell, you wanted to ask a question?
Yeah, I just have a few questions. I'm catching up on all this here now. So if we don't pass the legislation, we will be non-compliant with the Global Forum. And if we're non-compliant, we run the risk of de-risking, which is these foreign banks ending their relationships with banks in our jurisdiction. But you just spoke about something else. So an alternative to de-risking might be that these banks there may be an increased cost for auditing, an increased cost for the risk that we now present. And that increased cost will be passed on to the customer. Am I correct? Or maybe passed on to the customer.
I guess depending on what the cost is and where the cost is allocated, yes.
Right. So customers, in terms of doing trade externally, they may have to provide more frequent audited statements, and that is a cost, etc. Am I correct?
Yes, that's correct.
Okay. I just want to go back to something Mr. Ramke soon said. In your example, you gave about an exporter who exports an item and may not be paid. But in practice, that exporter will be paid. So he may opt to perhaps open an account in a foreign jurisdiction, and that may very well lead to capital flight. Am I correct?
And that's one possibility where the client, the exporter, retains his account. And of course, if he is onboarded in a jurisdiction where he can actually open an account, it can lead to that, where the foreign currency flows don't really get back into Trinidad and actually reside outside.
And in your opinion, do you think that some of our manufacturers may very well choose to set up in other jurisdictions where the cost may be less to do business?
Yeah, that one is a difficult one to really speculate on. I do know from our clients, really, they do maintain accounts, and they really do, for their working capital, utilize their funds. So it's difficult, and we really don't have the evidence also to really speculate more on that.
It is speculative. Two more questions. With respect to the credit card business, so citizens may not be able to buy something on Amazon because the credit card companies may choose to end their business with our banks within this jurisdiction. Or it could be that the cost to enter into transactions with your credit card may go up. Am I correct?
Yes. Increased costs at some point in time pushes at some point in some place. Some of it the bank may subsidize it to some extent, but if it continues to escalate, you may have to make a decision as to whether your degree of absorption or subsidizing the cost, whether there's a point in time that you need to translate or move some of these costs on.
Could I jump in here on a question Mr. Mitchell asked? I have discovered in the last couple of years that many merchants in the United States refuse to accept credit cards issued in Trinidad and Tobago. And they will only allow an online purchase if it's from a U.S. bank. Or let's say, for example, a Trinidad and Tobago citizen went abroad, opened a small account in Bank of America or something like that. they can then purchase online. And I'm just giving you information that I have received. I have no experience of this. JCPenney's, for example, you cannot buy anything online at JCPenney with a Trinidad and Tobago credit card. You have to have a U.S. credit card. Do you think that more and more of this can possibly happen, that merchants will refuse to accept cards that are issued in Trinidad and Tobago from Trinidad and Tobago citizens for online purchases? Result of this issue?
Well, I would say that with respect to the credit cards that are issued in Trinidad, I mean, those are not just solely issued by Republic Bank or any of the other financial institutions.
A Visa card.
Right, so that we are in partnership with Visa and MasterCard or Discover or Amex or something, and all of those, because of the strength of those international banks, are widely accepted. The instance where you have many of the companies on the internet that don't accept a card from Trinidad and Tobago is not a new phenomenon. That has always been the case. There are ways that once, I think the billing address is in a foreign address.
Yes, you can do that,
used.
but that too is being, that loophole is being plugged as well. Yes, even Visa cards, let's use Visa as an example, where the card has both a U.S. address and a Trinidad address. In the past, there were certain online retailers that would accept the U.S. address. Even that, they're going behind the card to see where it was issued.
Well, clearly, I'm not shopping as much online as you are, because I haven't encountered that.
That's why there's a tax on online shopping.
Good one.
Mr. Chairman, could I ask a question?
Mitchell had one more.
Oh, sorry.
Okay, so Mr. Mitchell, let's go.
All right. So from my previous questions and answers, I get the impression that the failure to pass this legislation will increase the cost of living in Trinidad. But lastly, and this one is of paramount concern to me, the money service businesses. Because, I mean, when you look at the socio-economic background of the persons who use these, they really depend on the remittances from their relatives abroad, etc. So that is the MoneyGram and the Western Union. Can you explain the negative fallout or the negative impact to persons who rely on these money service businesses if this legislation is not passed and we're non-compliant and we're de-risked, etc., etc.?
Well, simply put, those businesses would become non-existent, so that remittances would become a thing of the past. You would not. I know that remittances account for a fairly high percentage.
Could you just slow down? You say that if those businesses are affected, they'll become non-existent?
I said if the legislation isn't passed, there's a possibility that there will no longer be a remittance business because those businesses operate in foreign currency.
Wow.
Sorry, I was saying, Mr. Chairman, in the FATF world, this is well known that remittances have completely shut down. In Jamaica, it's almost it's shrinking. In Belize, it was dismantled, and people were literally without jobs because remittances are a complete closure. I was just going to ask a question. I thank
just 1 minute, Mr. A.G.
Yeah.
Have you finished, Mr. Mitchell?
Yes.
I thank Member Mitchell for that excellent line of inquiry there on a very, very important point. We've been talking Global Forum, but there's FATF, and Trinidad and Tobago is on the ICRG, the International Cooperation Review Group, progress. And the Bankers Association has been making constant inquiry of the Attorney General's office as to whether we are on track for our positions. In terms of financial intelligence unit, because this legislation touches that, and I've heard you say that you have no problem with the legislation. Could you tell us a little bit about the banking sector and suspicious transactions, suspicious activities? Because we note that the FIU observed $22.5 billion in suspicious transactions and activity reports and 13 billion of them were stopped. Could you tell us a little bit about the bank's concern, if any, about the elimination of terrorist financing, money laundering, corruption, as it relates to suspicious activities and transactions? The banking sector has an obligation as a financial institution under the Proceeds of Crime Act to make sure that it complies with the Financial Intelligence Unit requirements and the Proceeds of Crime requirements and the anti-terrorism requirements, that you report suspicious activities and suspicious transactions.
Correct.
This legislation is also required by the FATF. The FATF says that you must request a re-rating by November 30th. That's the deadline date for re-ratings. Is the bank concerned that if we are not able to keep our ratings and comply with FIU matters, because this bill specifically talks about the FIU, what is the bank's position in relation to that? Because Global Forum is only one part of the conversation. The FATF is another part of the conversation. Tell us a little bit about your suspicious transactions and activities in terms of what this bill does.
Well, I mean, we would continue to do our monitoring and continue to report as normal. Whether the legislation is passed or not, we have what it is we have to do. There are certain breaches that we would look for, and once we identify any sort of suspicious activity, whether tax evasion, whether committing, whatever it is, we will continue to report to the FIU in the normal course of business and do what we're supposed to do.
Wanted to do now. We have the next group is from National Anti-Money Laundering and Counter-Financing. So perhaps we could So I would like to thank you very much for coming, for your very forthright responses, and hopefully we'll see you again. Thank you very much. You could sit in the back if you want. Okay, what you're asking. We won't keep you long. I don't know why. Okay, we're ready. Okay, good afternoon. I am told that this group has a long name called the National Anti-Money Laundering and Counter-Financing of Terrorism Committee. And clearly a lot of people in it too. So that we are live. We are live on the Parliament channel, channel 11, on the Parliament radio station, 105.5, and on the Parliament's YouTube channel, ParlView. Could you please identify yourself and perhaps a leader of the group?
Good afternoon, Chair. Thank you very much. I am Viana Sharma, Legal Counsel in Ministry of the Attorney General and Legal Affairs, and I am the Deputy Chairman of NAMLAC. And before I go into the remit and mandate for NAMLAC, I would like the members at NAMLAC to introduce themselves, please.
Fine, great. I was going to ask you for the mandate anyway. So if you could get your team to introduce themselves.
Good afternoon. My name is Kylene Dowden. I'm a legal counsel for the Trinidad and Tobago Securities and Exchange Commission.
Good afternoon, Chair. Nigel Studdard, Deputy Director of the FIU.
Good afternoon, Chair. I'm Susan Francois, Director of the Financial Intelligence Unit.
Good afternoon, Chair. Avinash Singh. I am an Inspector of Police attached to the Financial Investigation.
Good afternoon, Chair and Committee. I'm Nadira Rahamatullah, the Manager of Anti-Money Laundering at the Central Bank.
Good afternoon, Chair. I am Ms. Sashri Singh, Examiner 2 at the Central Bank.
Good afternoon. Giselle Samuel, Senior Legal Counsel, Central Bank.
Good afternoon, Chair. Keisha Celeste, Legal Counsel at the Trinidad and Tobago Securities and Exchange Commission.
Thank you. And now perhaps you could tell us about your remit and your mandate.
Thank you, Chair. NAMLAC was established in 2006 as the National Committee for Money Laundering and Combating the Financing of Terrorism to monitor Trinidad and Tobago's compliance for ML and TF. So the remit of NAMLAC was revised in 2014, and the composition of NAMLAC is as follows. The Director of the Compliance Unit at the Ministry of National Security for Anti-Money Laundering and Combating the Financing of Terrorism, the Senior Legal Advisor to the Attorney General, Ministry of the Attorney General and Legal Affairs, the Director of Public Prosecutions, the Commissioner of Police, the Chief Immigration Officer, Controller of Customs and Excise, the Deputy Permanent Secretary of the Ministry of Finance, the Head of the Financial Investigations Branch.
Which Deputy Permanent Secretary, this one here?
Yes, please,
okay.
Chairman. The Head of the Financial Investigations Branch of the Trinidad and Tobago Police Service, the Head of the Central Authority Unit of the Ministry of the Attorney General and Legal Affairs, a legal advisor formerly in the Ministry of Justice, which is no longer applicable, the representative of the Legislative Drafting Department of the Ministry of the Attorney General and Legal Affairs, a representative of the Trinidad and Tobago Securities and Exchange Commission, and a representative of the Central Bank of Trinidad and Tobago. The mandate of NAMLAC is to make recommendations for the formulation of the national policy in respect of anti-money laundering and combating the financing of terrorism, and to engage with AML-CFT stakeholder community on the design and updating the implementation of action plans, priority steps, and risk assessments. It is to facilitate capacity enhancement across all national sectors and engage with the private sector as well, and facilitate exchange of information between the public and private sector through the creation of awareness workshops, publications, electronic sources of information, and national AML-CFT fora, to act as a forum of consultation and collaboration among reporting and supervisory authorities, accountable institutions, and organs of the state. Also to promote and maintain productive stakeholder relationships by coordinating the strategic level fora for the discussion of topical issues, including international developments and initiatives to inform the AML CFT policy and allow the authorities to identify priorities, bottlenecks, and possible challenges towards implementation of these policies. To provide technical assistance to the AML CFT stakeholder community by periodically reviewing the overall needs assessment of the various organizations that are involved or within the AML CFT framework for Trinidad and Tobago, conducting national risk assessments of the AML CFT risks and vulnerabilities in the various sectors, and providing awareness, raising seminars, symposiums on AML CFT legal framework and implementation of issues, to assist with the preparation and coordination of mutual evaluation visits, on-site visits with various ministries and agencies to evaluate the progress and results of the AML CFT activities and formulate proposals and recommendations for the Minister of National Security in his capacity as prime contact to the Caribbean Financial Action Task Force, together with the Minister of Finance and the Attorney General and Minister of Legal Affairs. So that, Chair, is a summary of the mandate and composition of NAMLAC.
Has the committee looked at the proposed legislation before us? Income Tax Amendment Bill?
Thank you, Chair. The National Anti-Money Laundering Committee has looked at the proposed bill that is before us. The bill has evolved from the deficiencies identified in the Mutual Evaluation Report of Trinidad and Tobago, which was published in June 2016.
This is FATF you're talking about?
The
This Mutual Evaluation
report that was published
with respect to the Financial Action
Task Force.
Caribbean Financial Action Task
Caribbean
Force.
Financial
Yeah.
Action Task Force,
Yeah.
which Trinidad and Tobago is a member of the Caribbean Financial Action Task Force, and it falls as an umbrella body of the FATF, the Financial Action Task Force. So our Mutual Evaluation Report for Trinidad and Tobago was published in June 2016, and it identified certain deficiencies in key areas that we needed to amend and look at. More specifically in relation to this bill, I could identify recommendation 29 that deals with the Financial Intelligence Unit requirements, recommendation 40 that deals with forms of international cooperation amongst sectors, including law enforcement and FIU and supervisory sectors, and then it deals with the effectiveness of that system. So you look at the international cooperation for immediate outcome 2 and how the whole system is working. So you demonstrate the effectiveness of your legislation in showing whether you are able to exchange this information and how effectively you are doing it.
Okay, for the non-lawyers among us, could you summarize that in layman's language? Are you saying that the Financial Action Task Force has told Trinidad and Tobago that unless we, 1, share tax information with other jurisdictions, other competent authorities, and 2, allow the law enforcement agencies to access taxpayer information in certain circumstances, such as with respect to a matter involving the proceeds of crime, that if we don't do that, we will be in severe trouble?
Yes, indeed, Chair. There are some milestones that Trinidad and Tobago is currently under. So upon the completion of our report, Trinidad and Tobago entered into 2 processes. And these 2 processes has led us to a point where we are at now, where we have to report to CFATF by Friday, 30th
Which Friday?
November. This
the day
Friday,
after tomorrow?
The day after tomorrow.
Okay.
In terms of the deficiencies that we've identified for technical compliance ratings, we are expected as a country to report on the status of our legislative amendments, which include this bill. So we are expected to, in accordance with the procedures set forth by the CFATF, to report on Friday. And then there is also the consideration in which we have to report. That reporting will take place this week, and we also will have to ensure that a submission is made to the FATF in January prior to the FATF meeting, which is held in February 2019. And that reporting requirement will allow the FATF to analyze and review the country's submission in relation to the exchange of information amongst competent authorities, which this bill seeks to allow for, and assess and determine whether we are compliant with the requirement that has been set forth and we have achieved to a certain extent or measurable extent the deficiency, we are addressing the deficiency sufficiently.
Okay. And if this bill is not passed, what happens?
The consequences of this bill not being passed will be quite severe, because our status quo right now for Trinidad and Tobago is that we are currently on the FATF grey list. We've been put on the FATF grey list because we are currently in the International Cooperation Review Group, which is a working group to look at countries and measure their progress in key areas.
Right.
One of the key areas treats squarely on international cooperation and exchange of information.
I think I got it in terms of us not being compliant. What I'm trying to find out is that if we continue to be non-compliant, what's going to happen to Trinidad and Tobago and the people of Trinidad and Tobago, the economy, people who have to do banking, you know, both here and abroad, what's going to happen to all of us?
Mr. Chairman, we're not non-compliant. We're in a process where we've made progress, and therefore they have noted in their publications that we have
we're on a watch list.
Yeah, so we are on a constant monitor where the international groups have said to you, Trinidad and Tobago, you're doing well. Right. You've achieved all the milestones you've set out, and they publicly commended us for that. And one of these milestones that we have to achieve this Friday is this bill.
Right, thanks for that clarification. Yeah. What happens if we don't pass this bill? Could you put it in ordinary language?
Well, the consequence of not passing the bill means that you haven't met the criteria.
And then what happens?
And then it means that you will then be downgraded, and you could then be blacklisted.
Seriously?
Or measures can be applied because it's a technical body
So if we are blacklisted, if we are taken off the grey list and put on the blacklist because of our failure to pass this bill, what happens to us as a country?
Well, the consequences are severe. So the FATF has set out a list of the enhanced measures, due diligence measures in recommendation 14, and it identifies the measures that correspondent banks would consider and apply to your financial sector and your risk to the global financial market, your risk to other FATF members and other FSRBs, meaning other sub-regional bodies. So there is a measured approach taken by FATF.
Ms. Francois, you wanted to come in here? Just now, Mr. Hines, we come to
Yes, Chair.
Go ahead.
Thank you. Chair, just for me to reiterate and support what Viana just said, that Trinidad and Tobago is on the FATF public list of high risk and other monitored jurisdictions. So right away, we are on this list, and it's called high risk. FATF has called upon countries to consider the strategic deficiencies applying to Trinidad and Tobago, as well as with other countries. And the ironic thing about this is that the FIU has the responsibility under the law to publish a list on its website and internally that Trinidad and Tobago is publicly identified by FATF as a country with strategic deficiencies. So we are being placed on the same list with countries such as the Democratic People's Republic of North Korea, Iran, Yemen, and the like. So that's the situation we are in now. If it is that we do not do enough come the February plenary, we are going to be put on the blacklist. That is the clear indication from FATF. But February is not, at the plenary, is not the point of assessment. The point of assessment is going to take place by the FATF ICRG, which is called the Joint Group, in the first week in January. So that we have to prepare a report, or while people are having fun at Christmas time, we are preparing this report, which has to go to the Joint Group by January the 4th, wherein we have to show that we have made sufficient progress. So the passage of the legislation is the first step. That will show that we have the foundation upon which to build the effectiveness. We need sufficient time as an AML CFT stakeholder in order to show effective implementation of this legislation. So if we have at least 6 weeks, 2 months, at least we have some time to show effective implementation of this legislation.
Not only do we have to give ourselves a legislative framework to share information, tax information and so on, and allow the law enforcement agencies to do what they are required to do. After having done that, we have to put it into action. And we have to show that we are actually implementing it. So time is of the essence.
Deadline for reporting is this Friday. Friday the 30th is the deadline by which you must seek your re-ratings. If you don't seek re-ratings, then you are going to slide in your listing.
Yeah. Chair, may I just remind there are 2 re-ratings we are looking at. Re-ratings on the technical side, which means that we have passed the legislation, and that that submission has to take place by November the 30th. Then we are seeking re-rating on the effectiveness side, which we have to send that report in early January. So it's 2 assessments we faced by CFATF in 2015. So it's 2 sets of re-ratings, if you want to call it, that we are facing now. And may I just add to what Viana was saying as well, with respect to the countermeasures which would be applied to a country which has been blacklisted by FATF. We need to simply look at what FATF has said about the Democratic Republic, People of Korea, and Iran. And there's a call on all countries, all countries are members of FATF, all members, and urges them to apply effective countermeasures and targeted financial sanctions in accordance with the UN resolutions to protect their financial sectors from money laundering, financing of terrorism, and weapons of mass destruction. So that's a call by FATF for countries on that blacklist. So all countries in the world globally must comply with FATF's call for countermeasures. And these countermeasures would basically include not trading with the country which is on the blacklist, not conducting transactions with that country which is on the blacklist. And we just have to look at the situation which took place in 2000, 2001, 2002, which is with Cayman Islands, Bahamas, St. Kitts, Nevis, those countries which were blacklisted by the FATF. And some of them say they are still recovering from the negative consequences of that blacklisting. Thank you, Chair.
I notice we have representatives of the Financial Intelligence Branch, Central Bank in this group, and the Securities and Exchange Commission. So perhaps we can save some time because we were bringing you separately. But since you're all here, perhaps, Inspector, you want to give us the perspective from the police in terms of why this legislation is so important?
The legislation allows the police, obviously, to have greater access to information, so long as the jurisdiction that sends the information has similar laws and consents. So it is of great benefit to us to have the information so that the investigations could move along in a quick time. Well, it delays the investigation. We may not be, if we are not able to access that type of information, we may not be able to explore angles that we would usually be able to do locally in respect of local agencies. So,
some ambiguity as to whether this legislation applies only to offenses under the Proceeds of Crime Act and also the terrorist financing legislation. Could you clear this up? Could you give an example of what type of tax information a police officer would be seeking to, and we're amending it to allow judicial oversight. So you'd have to apply to a court to get it. What sort of information, and give me an example of a circumstance where the police might want to go and access this kind of information.
our purpose is to ascertain, or would be to ascertain, the legitimate income of a person. So an example would be, we may be investigating someone who we suspect to be involved in money laundering as well as other illicit offenses, maybe drug trafficking. Right. To ascertain his legitimate income, his declared income to the Board of Inland Revenue might be one aspect of being able to find his true source of income. It may not be his true source of income. He may declare a lesser amount to evade taxes. He may declare a larger amount for the sole purpose of laundering money. So it's one of the agencies we would go to start to build a picture to find a person's legitimate income.
To have this instrument in your arsenal, it's going to be difficult for the police to do any sort of comprehensive investigation on alleged money laundering or an alleged offense under the proceeds of crime.
Yes, definitely.
Okay, AG, okay, Securities and Exchange Commission. Why is this legislation important?
Thank you, Chair. Mainly for the fact that a lot of the securities transactions that occur in Trinidad and Tobago rely heavily on the banking sector. So any sort of de-risking imposed on the country as it pertains to correspondent banks would affect the security sector directly. There are many wire transfers that the local broker-dealers rely on when they're making their transactions on behalf of their clients. You'd also look at certain collective investment schemes that would invest heavily in U.S. securities. And
all right, but not all bankers. What's a collective investment scheme?
Sorry. That is similar to your mutual funds.
A mutual fund,
yes.
Okay.
Like unit trust.
Right.
So say your U.S. dollar mutual funds would invest in U.S. securities.
Like the money market, U.S. dollar unit trust money market fund.
Yes, Chair.
Fine.
So those sort of investments rely on the relationship between the investment advisor in Trinidad and the broker-dealer in the U.S. And if it is that there are negative statements made against Trinidad in the U.S., for example, and those broker-dealers have to impose enhanced due diligence on our local investment advisors, local broker-dealers, there will be an increased cost. There may be de-risking as well of our
So it could affect the local stock market?
Yes, it would.
Are you aware if any stockbrokers have complained that they have lost services and bankability?
What we have been hearing is that there is an increased cost. There has been no complete loss of ability at the moment, but there has been an increase in cost.
Okay. I have a particular question I would like this clarified. This bill has two branches. One is to allow the sharing of taxpayer information with competent authorities in other jurisdictions. The other is to allow the police to get access to taxpayer information when you're investigating a particular crime on the proceeds of crime and so on. I'm told that the second one is a FATF requirement. Can we get clarity on that, the requirement for the police?
Chair, if I may, the FATF requirement are set forth in recommendation 40 and 29, and then immediate outcome 2, more so for recommendation 40. They identified a deficiency where there is the secrecy provision in the Income Tax Act for Trinidad and Tobago that prohibits the BIR from sharing that taxpayer information with all law enforcement authorities, and therefore thereby preventing and hindering the investigation of the offense. So they are comprehensive investigation.
So what FATF said is that for the investigation of financial crimes, this is necessary, that the police should be able to get access to taxpayer information under certain circumstances. And this is not possible at this point in time.
Mr. Chair, it's also for terrorist financing.
Yeah,
so
I understand.
Right?
Yes, please, Chair.
And they put it in black and white as a specific point in that recommendation.
So FATF has said that we must
amend
have
this
our law,
in place
must
for
amend the
technical
Income Tax
compliance.
Act to allow law enforcement access to taxpayer information in these circumstances, investigation of a crime under proceeds of crime or terrorist financing.
And any
and
other...
it's in writing.
Yes, and for the requirement, and it's set forth in recommendation 40 and any other predicate offenses.
And when are we supposed to have achieved this?
Well,
the amendment of the law to deal with that matter?
We are rated right now partially compliant for this recommendation, and we would be seeking a re-rating, so this would be due by Friday. It would be included
Same Friday,
in all re-ratings
tomorrow?
applications.
So
So
by
we
the
have
day, yes, just a minute, Ms. Sharma. By the day after tomorrow, the police should have the ability to access taxpayer information in these circumstances for terrorist financing, proceeds of crime, by Friday of this week, the day after tomorrow.
Yes, please, in accordance with the procedures.
Right. Mr. Hines?
Chairman, I would like to direct this question to Madam Francois of the FIU in particular. Some time ago, very recently, your organization under law reported to this country's parliament that you had encountered in the course of your work and observations, you had encountered some $22 billion worth of suspicious financial transactions going through our banking system. Is that correct?
That is correct.
So the question is, what are the implications for the deficiency that was just highlighted by Mrs. Sharma in respect of that observation of $22 billion worth of suspicious transactions in our country and jurisdiction?
The 22 billion identified TT dollars, to be clear, involved both a completed transaction and an attempted transaction, which together totaled, I think, approximately $20 billion. The fact that the reporting entity was able to stop the attempted transaction from it entering into the financial system shows the extent of their due diligence and that they are, in fact, implementing their legal obligations with respect to anti-money laundering and counter-financing of terrorism obligations. And that transaction was a fraudulent transaction. The other transaction was a completed transaction. However, there was insufficient, we found, the reporting entity as well as the FIU did not have enough to go on to reach a threshold of reasonable grounds to suspect that the transaction was related to money laundering. So at that point in time, and we still have identified that as a suspicious transaction, but it is undergoing more analysis as we get more information. So the FIU's mandate under the law is to follow the money trail. So we follow the money trail from the source, identify where it came from in the first instance, and then to the ultimate destination. So that analysis is conducted to determine whether, in fact, this money that we're looking at is legitimate earnings, it came from criminal conduct, or is intended for use by terrorists. So that's the money trail. And with respect to this particular legislation that we are looking at now, which is the amendment to the Income Tax Act, to give the FIU, or to enable the FIU to access taxpayer information for the purpose of conducting its analysis. That information is important to the FIU in determining whether earnings are legitimate. So although there's a suspicious transaction filed with us by the reporting entity, that does not necessarily mean that this person is committing a criminal act. So we have to conduct analysis to determine whether we can clear that person, for example, or we need to pass on that case to law enforcement. And tax evasion is criminal conduct under the law, which can lead to a money laundering offense. And based on the FIU's analysis throughout the years, we have encountered many cases of suspected tax evasion. We have seen indicators such as, and I could just repeat some of them if you wish.
Sure.
Okay. Tax evasion indicators that we have observed include commingling, that is putting business proceeds into a personal account. So business account supposed to have business proceeds and personal accounts are supposed to have personal proceeds. So you mustn't confuse both. So if you need to show how much your business earned, that's what the business account is for. We've seen large deposits of cash into personal accounts, and the source of this money is unverifiable because it's cash, and it's unverifiable in the sense that the reporting entities may not have been able to receive a clear explanation for the source. And sometimes as well, persons, you may think that the person appeared before the counter to deposit the money, but oftentimes persons use the night safe for checks and cash. So it's only when this money is being counted by the bank to go into the account, they see this money. So they have to put it into the account and then ask for an explanation. Then we're seeing business funds being repatriated abroad, and there's no reasonable explanation for it. Why is it this money is going in that particular way? Structuring of transactions, you know, the banks would have a certain reporting threshold. So transactions before over that, they may ask more questions. So persons, in order to avoid that, they will put in money, many deposits, but consistently below that reporting threshold. And finally, this is a very important one, is complex transactions. And the purpose of these complex transactions would be to hide who actually owns the money. So that way, again, persons can avoid the tax liability. And the FIU's analysis throughout the years, this is from 2011 to present, has consistently identified tax evasion as being in the top 5 categories of suspected criminal conduct leading to money laundering. In fact, I could say from 2011 to 2018, we have sent about nearly 300 reports to the chairman of the Board of Inland Revenue on suspected cases of tax evasion. And it's important to know that the amount of money involved in the suspected tax evasion cases is pretty high. In terms of being a category, it generally numbers 3 or 4 in the top producers of illicit proceeds that the FIU is seeing.
So that this amendment to the income tax bill that we are treating with at the moment proposes to give to you, the FIU, and you, the Trinidad and Tobago Police Service, access to tax information, and that information must, from what you have said, be of great value and assist you in determining what those transactions really are about, and in the case of the police, working towards prosecution. Am I correct?
Yes, that is correct, Chair.
So without access to that information, your work as an FIU and your work as a police service, the only organization chartered to do that kind of work in Trinidad and Tobago is adversely affected. It is stunted. It is stymied. Am I correct, Inspector Singh?
Yes, I just want to clear the air on one issue, and that's with respect to the issue in relation to us having access. Currently, we can get access to that information by virtue of Section 32 of the Procedure of Crime Act. What this provision in the Income Tax Amendment Bill will allow is for us to get it quicker. The process of going through Section 32, it means that we have to do, based on the complexity of the matter, an affidavit, an application, and a draft order. We need to go to the High Court and have a judge look at it. That process takes time. If the case is a complex one, the affidavit is going to take days to complete. So that's the issue there. It's not that we don't have access to it, we do have access to it. But this provision will allow us to have it.
And time is critical. And more than that, Ms. Sharma, finally, the CFATF, having looked at what we already have, feels that it is a deficiency and it ought to be improved in the way we are now offering this amendment to the Parliament. Am I correct?
Yes, please. It has been identified as a deficiency in the mutual evaluation report.
Thank you very much.
Can I ask you, Ms. Sharma, to just let the country know some of the training and qualification work that you do at CFATF and on the Global Forum? And can I also ask you to tell the country other examples of other laws where there is this kind of access permitted?
Could I ask you, Ms. Sharma, because you have some other people to interview, if you could summarize it quickly for us, please.
Sure. So in relation to my role at CFATF, I am a co-chair for the working group on FATF issues. So we look and measure countries' compliance in the CFATF and the level of compliance with the standard. So I am the co-chair for that working group in reviewing other members' jurisdiction. We recently had the CFATF plenary meeting that took place in Barbados, and I did review the mutual evaluation report for Cayman Islands, where there was a measurement and a review of their process. I'm also trained as a global forum assessor, or a global forum with the standard, the common reporting standard and the automatic exchange of information. So I'm able to provide input to the NAMLAC and to the global forum working team in relation to specifically the requirements as set forth by the global forum for the criterion listed, and furthermore in relation to the removal of the requirement for accession onto the MAC. So those are the two questions. The last one being the query in relation to countries that have already acceded to...
Examples of countries that have laws of the type that are coming here.
Countries that have laws of the type in the Caribbean are Barbados and Jamaica have already been identified as compliant. So those are two that come to mind quickly, both in relation to the global forum requirements and for the
So we're not
CFATF.
we're not doing anything unusual.
No.
In fact, we are behind the other major countries in the Caribbean.
Yes, we are behind in terms of the leap that Trinidad and Tobago has to make, our leap being a very wide, a long one.
Would you tell the country about Trinidad and Tobago's place in the line, having been reviewed first, whereas other countries who are reviewed later than us, are in fact ahead of us?
Well, Trinidad and Tobago has been reviewed first by the CFATF because we're first in line. So we've had our mutual evaluation report prepared in June 2016, and we are therefore, hence the reason we are expected to provide this update by Friday, because the procedure is set forth and
So
we accede to that.
we are way behind.
So
Minister
we are way
Mitchell,
behind versus
I'd just
other
like to
countries.
ask Minister Mitchell, did you want to ask any question?
One quick question. I know that you are in charge of, part of your mandate is for the formulation of national policy as it pertains to money laundering and terrorist financing. In terms of money laundering, can you tell us what are the negative impacts to a country on the proliferation of money laundering in the system? Now, we've heard about a lack of productivity. We've also heard that money laundering is suspected to be a main driver behind the 2008 financial collapse. But just tell us in layman's terms, what are the negative effects to money laundering in a developing economy like ours?
I'd just like to say firstly, money laundering is from criminal proceeds. So any criminal act could generate proceeds which are laundered. And the criminal acts we are looking at include things such as trafficking in human beings for all different reasons, trafficking in arms, ammunition, corruption, bribery, fraud, murder, kidnapping, robbery, theft, tax crime. So all these crimes generate money which can be laundered. So if the money launderer, the criminal, is allowed to be successful at money laundering, what naturally happens then, we go back to the old adage, crime really pays. So then, therefore, there will be nothing to stop persons from continuing to commit crime because the benefits are being reaped. And I think that is something that we must remember. Too often it is said that money laundering is a white-collar crime. Money laundering takes place after, I call the real crime, the crime which generated the money. After that crime is money laundering. So without that first crime, which is all the things I spoke to you about, trafficking in arms, corruption, fraud, murder, kidnapping, robbery, tax, extortion, forgery, etc. Without those crimes having first taken place, there could be no money laundering. So if you just have to consider the consequences of crime going unchecked, of criminals benefiting whole scale without anyone to stop them. And that will be the consequences we face.
Central Bank, may I ask for your perspectives on the importance of this bill? Because you regulate the entire financial sector under the purview that you do. And the last question that I'll ask, we have Securities Exchange Commission, Financial Intelligence Unit of Trinidad and Tobago Police Service, Central Bank of Trinidad and Tobago, Head of National Anti-Money Laundering Committee, who sits in the CFATF working group. The question I'll ask all of you after Central Bank comes in is, what, if anything, do you have by way of concern with the law that is before us now in the bill that is before the Parliament? Central Bank?
Reps can answer.
I'll take the first shot at that. I think I support everything my colleagues have said before, as well as bad comments on this in terms of the impact. So I think it's rather than rehash that, it's very important to reiterate the point that this country signed on to certain international conventions, some of which facilitate or require, in fact, the sharing of information in respect of money laundering, terrorist financing, and tax evasion. So that essentially, in a nutshell, is the critical importance of this bill, because the amendments seek to address requirements that we are required to conform to. And
agreed as a country years ago,
that's right.
Not recently, years ago, under the previous administration in some instances, to do all of this.
Yes.
Okay, thank you. I really appreciate your contributions. We now have the Chambers of Commerce in the back, so I think we've heard more than enough.
Mr. Chairman, insofar as this goes into a report, and I'm so sorry to interrupt, could I just ask Central Bank to finish its point?
Yeah, no problem.
Yeah?
Okay, AG, okay, no problem. Would any of the other reps from the Central Bank like to say anything? In the back?
Not at this time, Chair.
No
We
problem.
defer to
So,
Ms.
I know. So that Ms. Rahamatullah, please proceed.
Just to end on that point, it's simply to demonstrate once we've signed on to these conventions as a country, we need to demonstrate that commitment, that we are willing to do what is necessary. And that reflects well at the international community level. And previous speakers would have spoken about the impact in terms of international trade, if the country is perceived as high risk or not being compliant with international standards. That has a real impact on everybody. So I will end there just to say that essentially that is the importance.
You are in total support of this legislation?
Once the legislation meets the requirements in terms of the sharing of information,
Yes.
the path of concerns as well as the global forum.
Thank you very much.
Does anyone have any opposition to the legislation in the several entities that are here?
No, AG, we don't.
Very much. Okay. All right. Okay. All right. We have a composite of the Trinidad and Tobago Chamber of Commerce and the American Chamber of Commerce. Is there a TT inside of there somewhere? Okay, fine. This select committee hearing is live. It's live on, I was just checking because I've been activating the live and deactivating as people come in and out. It's on Channel 11, the Parliament channel. It's on 105.5 radio, the Parliament radio station, and it's on the Parliament's YouTube channel, ParlView. This committee has 4 members at this time: Mr. Fitzgerald Hines, MP, Mr. Faris Alwari, who will join us very shortly, MP, myself as chairman, and Mr. Randall Mitchell, MP. So far, we have consulted with a number of groups, the ambassador to the delegation of the European Union of Trinidad and Tobago, the Bankers Association of Trinidad and Tobago, the National Anti-Money Laundering and Counter-Financing of Terrorism Committee, which included representatives from a wide range of groups, such as the Financial Intelligence Unit, the Securities and Exchange Commission, the Financial Intelligence Branch of the Trinidad and Tobago Police Service, the Attorney General, Office of the Attorney General, Central Bank of Trinidad and Tobago. All of those persons are represented on the National Anti-Money Laundering and Counter-Financing of Terrorism Committee. So we took the opportunity, while we're interviewing that committee, to also interview the individual entities, FIU, police force, etc. And now we have the 2 chambers together for reasons of efficiency. And I'd like to start off immediately. Perhaps the representative of the American Chamber can tell us why this legislation is so important and why it's critical with respect to banking relations.
Good afternoon.
Sorry, you should also introduce yourself. My apologies.
Good afternoon, Mr. Chair and members of the committee and staff, colleagues. I'm Nirad Tiwari. I'm the CEO of AMCHAM Trinidad and Tobago.
Good afternoon, everyone. Aurelia Bruce, Research Officer at AMCHAM TNT.
Well, you have to put on your mic and say who you are.
Sorry. Suresh Kasi, PwC, member of the TT Chamber.
Fine.
Karen Yipchak, one of the directors on the Trinidad and Tobago Chamber of Industry and Commerce, and with me I have Baldat Ramkisoon and Joel Chada, representing members of the Trinidad and Tobago Chamber.
Thank you very much. So, Mr. Tiwari, over to you.
Mr. Chair, thank you for the opportunity to come before the Select Committee. We recognize the importance of not only this, but the legislation required to ensure that we effectively combat money laundering and terrorism financing, but as well, equally as important, tax evasion. Because a system which allows corruption to flourish is a system which disincentivizes business activity. So this is important, or these pieces of legislation, I know we're here discussing one, but these pieces of legislation are extremely important in making the jurisdiction more efficient, fairer, and ensuring that the kind of business that takes place here is business that we want to take place. With regards to this specific piece of legislation, we understand it to be a critical part of the legislation required to ensure that we are able to participate effectively and fully in the international financial system, which, as it stands, is an integral and essential component of facilitating trade. So that's the answer to your...
And if it is not passed, what will happen?
Well, I think you've heard from more competent authorities than
Well,
us.
we want as wide a perspective as possible.
If this piece of legislation is not passed, it is our understanding that at some point in the near future, our correspondent banking relationships will be at risk, and therefore we will be unable to participate in the international financial system in the way that we are accustomed and in a way befitting our status as the largest economy in the CARICOM, as the largest financial services sector in the CARICOM, and as the financial hub of the Caribbean. However, it is also our understanding that this piece of legislation alone will not solve that problem. And therefore, we are very concerned not only about this piece of legislation, but the other pieces of legislation that are required to ensure that the effects which we've been talking about do not, in fact, come to pass.
Certainly, but this committee is simply about this bill only, because the only bill that this committee is empowered to look at. We have a mandate to look at it. Could I ask the Trinidad and Tobago Chamber for their comments?
Okay, well, the Chamber endorses the passage of the Income Tax Amendment Bill as it is meant to give the green light to sharing of information, of tax information with the foreign agencies. And we'd like to quote here that since 2017 and 2018, we have seen that public sales of foreign exchange have averaged about $5.4 billion US. It was previously about $6 to $7 billion US per annum, 2016, 2015.
It was actually over $7 billion.
Which really signifies the amount of trade that our business community does and is dependent on foreign exchange, which really needs the passage of this bill to continue to facilitate.
Okay, is there any other member of the Chamber who would like to say anything? The Trinidad and Tobago Chamber, that is.
Mr. Chair, may I ask a specific question?
No, just let me hear from them first. Is there any other point you all would like to make? Okay, let me ask you a question. What will happen if this bill is not passed? Can I ask the Chamber that? Trinidad and Tobago Chamber, sorry.
So, thanks for that question, Chair. We do see on trade that there will be a negative impact, largely hinge on the fact that the possible withdrawal of correspondent banking services to the commercial banking sector will be impacted. And that will translate down to all forms of businesses.
AG?
Thank you. Question to AMCHAM, please. What specific concerns do you have in relation to the bill?
Thank you, AG. If you'd permit me, our first concern relates to the process and the fact that we're back up against a deadline again when we were aware that we needed to pass this legislation well in advance. We don't think it engenders confidence in the entire economy because, as you are well aware as a commercial attorney in a previous life, investment decisions are taken on the balance of the whole and the system. And so when all parts of the system work effectively, we're much more likely to be attractive. Specifically on the bill, we do think that the fines for breaching the secrecy provisions are quite low. I mean, 100,000 TT dollars, 150,000 TT dollars in today's world is, it might be an incentive rather than a disincentive. So,
since you deal in US dollars?
We deal in TT, US, euros, hopefully Bitcoin sometime soon.
Fines and?
We agree with the suggestion. We are in receipt of the letters both to and from the Minister of Finance and Opposition Leader.
Sure.
We do agree with the suggestion that some base level of, forget what it's called, evidentiary burden be established for the judicial oversight. I mean, I think that makes sense.
Yeah.
So those were two. And in as much as this amendment bill deals with the secrecy provisions or waiver of the secrecy provisions of the Income Tax Act, we have a question and a suggestion regarding the Auditor General. We've seen in the past where the Auditor General has not been able to get information from BIR in pursuing audits and following the money, as it were. And we wonder why the Auditor General is not included in the list of institutions that would be a beneficiary of the waiver of the secrecy clause.
You see, we're trying to focus on dealing with our international obligations as they relate to the EU, Global Forum, and FATF. There are several amendments we need to make to the Income Tax Act, but we didn't want to widen the scope of this legislation in order to create avenues for opposition, so that we're focusing directly on the FATF requirements and the Global Forum requirements. That will come, what you are asking about.
So if I were to say, if we were to treat with increasing the fines, providing for a standard of proof that a judge must be satisfied, there should be TTPS involvement, which is not an obstacle, as you would have heard the TTPS say a while ago, right? Because the problem with the POCA, the Proceeds of Crime Act, is that it's burdensome. So if we were to adjust the fines, allow for judicial supervision with a standard of proof stated, AMCHAM would be happy with that particular perspective.
Yes, and we did also note, or we do also note that the legislation is specific to which part and what rank of the police service can access the information.
So do you find this bill vague or imprecise in any fashion?
I'm not sure if I'm being asked what you lawyers call a leading question, but to me, in my reading of the bill, I am able to understand what is being asked and what the bill seeks to address, and in that regard, it is clear.
Okay.
But I'm not a lawyer.
No, that's all right. Mr. Hines.
In particular, AMCHAM, my business is not to give evidence from here, but I feel, yes, but I feel that I owe it to you, and I owe it to you to tell you that this bill, in response to your implied question as to why do we get to the deadline hour, I feel I owe it to you, since you've been kind enough to come here to assist us today, to have you know on the 28th of May, this was put into the Parliament, and of course it went to a joint select committee, and it has gone on and on up until today. So the delay has its tracing in that kind of history. But in addition to this, 5 clauses of the current bill are particularly and intimately familiar to every one of us 41 sitting in the Parliament, because we have traversed those identical clauses before. They are a replication of what we dealt with already in FATCA. And the first 4 clauses of this bill are inoperational, like the title, short title, and that sort of thing. So we've really engaged in some time wasting, which has brought us to where we are today. And finally, as a follow-up on what the chairman said a while ago, I think I'm obliged to tell you as well, since you mentioned you would like to see the other pieces of legislation. For many citizens of this country, that would mean, very specifically, the other 2 bills that had gone to the Parliament on May the 28th, along with this income tax measure. The CFATF and the Global Forum have made it abundantly clear to the government of Trinidad and Tobago that it is only this income tax amendment bill that is critical to take us out of the troubles that you have identified?
AG, you can come in after me. The Global Forum and the EU have constantly moved the goalposts. As we get to the point where we think we're compliant with the last set of conditionalities that they told us, they change again. These organizations meet on a, is it biannual? More than biannual?
So FATF sits...
No, not FATF. I'm talking about Global Forum, EU. And then FATF sits...
Two plenaries in Global Forum, and then 4 plenaries in CFATF and FATF.
Right.
So they meet 6 times per year.
So as they meet, new things come at us. And one of the things we did with this legislation, just to make sure we weren't caught off guard, is that we sent the draft legislation to the Global Forum, to the OECD Secretariat, and asked them to look at it and to comment. And they reviewed it, and they made minor adjustments to the language, but they didn't trouble the substance of the legislation. So that we could have been here a long time ago. But as I said, the goalposts keep moving. Now we have issues which will be dealt with in due course with respect to free zones. That's a new thing that has just come out of the blue, that the Global Forum has defined a free zone as a potential for harmful tax practices because you have varying rates of tax in a free zone. So that every other month, something new arises. So that also contributed to the delay.
Just to add, specifically in terms of process, the process involved, and this is on the record, us having to fast track the Global Forum. So because we signed on in 2010, 2011, 2014, we gave commitments to observe certain things. We were specifically told that we had to negotiate 13 treaties. No treaties were done. We were compelled, therefore, to get into the Global Forum fast track process and be bounced, because they said, you can't come into this fast track unless you amend your Income Tax Act. And then that Income Tax Act allows you to unlock the multilateral treaty, which you can sign on to. And therefore, if you do that, then you can get into the point. So it's just like FATCA. In FATCA, we had to go and agree to be part of FATCA. We signed the intergovernmental agreement. And then we brought the intergovernmental agreement into law with the FATCA bill. By passing the Income Tax Amendment Bill, we'll be allowed to sign the multilateral treaty, and then the multilateral treaty can come into legislation. So that's the difference. But this has involved literally the Ministry of Finance and the Attorney General's office working with the Global Forum on a day-by-day basis almost. And the goalposts shifted.
One of the problems we faced in going to these meetings with the Global Forum is that we wanted to sign the multilateral treaty, which will allow us to enter into arrangements with other jurisdictions quickly. But they told us that they would not allow us to sign the treaty until we pass this income tax amendment law. Reason being that it would have been a nonsense because the treaty commits to the sharing of information, of tax information, to the Global Forum countries. So that unless our laws already allow us to do that, it would be a nonsense for us to sign the treaty with the Global Forum countries. So they refused permission to Trinidad and Tobago to sign the treaty that deals with mutual assistance. That is one of the other bills. All the other bill is the incorporation into our domestic law of that multilateral treaty, which we cannot sign. And the way this legislation is constructed, that type of legislation, is that you sign the treaty, and then you come to Parliament with a bill to incorporate the treaty into domestic law. We can't even get to the point of signing the treaty because they've said that we must amend Section 4 of the Income Tax Act first. So this is why this bill is so important as an essential precursor to anything else. If we don't pass this, we just spin in top in mud. The other legislation is irrelevant.
Just remember there are 2 goals, right? FATF says Friday. You don't meet that, you're gone on FATF. Global Forum is another story. So there are 2 things in one.
Mr. Chair, through you, we, as I said, we fully support the passage of these pieces of legislation. We do recognize the competing concerns in an evolving system around privacy as well. And I gather the committee and the parliament are looking at that based on the reports. So whether we pass this bill and then the next two, or whether we pass all three together, is of zero import to us, as long as we do pass all three and pass them and become compliant by what seems like an end of December deadline in reality for the global forum, component, as it will. We understand the FATF is different. Our concern, though, stems from the fact that we are one of just a handful of countries in whose company we do not want to be, who have been blacklisted and who find ourselves in this position, when we, quite frankly, should be one of the economic leaders in the world. And unless we can fix that, it is okay to say why we got here, but now we are here. And we have to, from our point of view, and this is not a self-interested business point of view, this is for the country and for every citizen who wants to have the ability to receive a remittance, to send their child to school and send money to them, or for businesses that need to do large and complex wire transfers. We need to have a system that facilitates our participation in the global economy, because our reality is that we are a tiny country and we cannot rely on internal markets and our physical and geographic space alone to be sustainably happy and prosperous.
Bill is important.
It is important, as are the other two, Mr. Chair.
I'm not examining the other two, Mr. Tawari. We'll get there. Does anybody else from the chambers want to say anything? Okay. Thank you very much. Thank you. Okay, Kiba. Board of Inland Revenue, could you identify yourselves, please? Thank you. Just to let you know, we're live on Channel 11, 105.5 radio, and ParlView YouTube channel of the Parliament. And this is the Select Committee that was established to examine the Income Tax Amendment Bill, which deals specifically with Section 4 of the Income Tax Act, among other things, to facilitate the sharing of tax information with other tax authorities, similar to what we did with FATCA, among some other things. The members of the committee are Mr. Fitzgerald Hines, MP, Mr. Faris Alwari, MP, myself, Colin Membert, as chairman, and Mr. Randall Mitchell, MP. Could I get straight into the business of the committee and ask the Board of Inland Revenue first to introduce yourself, your team?
Okay, well, I am Alison Raphael. I'm chairman of the Board of Inland Revenue. I will ask the others to introduce themselves, if that's okay.
Chairman, my name is Shireen Aziz. I'm the Chief State Counsel.
Chairman Neela Ram, ICT Director.
It's important to us with respect to the exchange of information, all right? Because as I heard you before, you said it so lovely, the issues surrounding the necessity for this information. Because right now, as you said, we can't sign any agreements. Now, once we have that exchange, of course, we will get information from other jurisdictions, and of course, we'll use that in the whole compliance process. So it's really important, yes, very much so.
Citizens of Trinidad and Tobago, or Trinidad and Tobago companies that are doing business in Europe, for example, they will provide you with information on these activities. I will help you in your compliance here in Trinidad and Tobago.
That is correct, yeah.
Okay.
So,
do you have any objection to the legislation?
with respect, there's one little area that if I could mention, with respect to the police.
Yes.
Right now, we have the production order, and it works very well with respect to the police getting information from us.
Yes.
And I will suggest that we keep that.
Now, could you clarify what that means for the general public?
What the production order? Well,
yes.
I don't know if I could
Not
ask
all
you
lawyers
the details. Oh, well, I'm not one either. So I'll ask Ms. Aziz, are you okay, to speak to what the production order is about and what it entails?
Under the POCA, that's the Proceeds of Crimes Act, the police would go to the High Court to get an order from the judge. It's called a production order, which enables the police to come to the Board of Inland Revenue to request information on certain taxpayers. Normally, they would serve the BIR with the order, and we will get access to information as required under the order for the police officers to collect. Now, that is the order we use to, get the information. Without the order, we don't normally give that information to the police at present.
You told us that that's tedious and cumbersome for them, not for you.
Well, for us, it's not tedious in the sense that when they present us with the order, we just have to access the information.
I understand, but what they told us that it takes quite a while
Mr. Chair,
to get to that point.
The reason that it's been negatively treated by FATF, FATF reviewed the Proceeds of Crime Act, in particular sections 31, 32, 34 of the Proceeds of Crime Act, sections 44 and 45, and they held the view that Trinidad and Tobago needed to come to standard with other jurisdictions. That is, to have an exception from the secrecy provisions. Because what's done under POCA is done on a balance of probabilities. So it is not a warranting type of information on reasonable grounds. It is at a different level, and that is what the burdensome aspect is. So the judicial authorization on reasonable grounds is very different from judicial authorization on balance of probabilities. And we have been singled out in the mutual evaluation report as being non-compliant for that reason, and in need to amend the law so that it's chalk and cheese. So from the BIR's perspective, it's one thing, but from every other country, Barbados, Bahamas, etc., there are actually no secrecy provisions that apply for TTPS equivalents.
Telling us is that the standard of evidence that they have to produce is quite high, and it takes them quite a while before they can even arrive at the court and make the application to the judge under POCA, under the Proceeds of Crime Act. Whereas this legislation allows them to do it much quicker, and you know, it makes the process more efficient. What I would like, AG, if you'll help me, I'm a non-lawyer. We have three standards. We have reasonable cause, we have balance of probabilities, and we have beyond a reasonable doubt. And those are all in ascending order of difficulty. So reasonable cause is the lowest threshold, then balance of probabilities, then beyond a reasonable doubt. Right now, we are at balance of probabilities, which is in the middle, in terms of the evidentiary standard that the police have to reach on the proceeds of crime. And as the AG has pointed out, this is, has been found to be a deficiency on the part of Trinidad and Tobago.
Mr. Chair, there was actually a very landmark judgment that came, I'm sure you're all aware of it, in a particular case to deal with Norwich Pharmacal orders, which is production of information orders as it relates to financial disclosure. And the Norwich Pharmacal standard is mere suspicion. And our Court of Appeal has upheld that. So to maintain the proceeds of crime balance of probability standard is to be out of tune with what our own courts are actually saying here. That the entire Court of Appeal unanimously agreed in a landmark decision given just this month that mere suspicion ought to authorize a bank to disclose the same type of information that the Board of Inland Revenue is being asked to do. Understand that this is not being done without judicial filter, and there are remedies for it as well. So that's the importance of this.
Could I suggest that we elevate the requests from the Commissioner of Police rather than from, I think in the law says, speaks to a superintendent? Is an inspector?
I'm not sure if that's practical.
Yeah.
AG,
so I would
practical?
It's not practical?
It's not practical because of the senior, well, first of all, there's a safeguard. In the TTPS, there's a senior-junior operation factor. So senior officers sign off on it. But to even put it at the Commissioner of Police is to lose sight of the fact that the Commissioner of Police can delegate responsibilities. But one Commissioner of Police in the realm of money laundering, tax evasion, financing of terrorism, which, as you heard the FIU point out, relates to matters such as murder, kidnapping, trafficking in human beings, that would be to restrict the system. So the safeguard is that a judge says give it. And respectfully, if under the production orders, the BIR is already happy with the judge giving it, what's the difference?
Is there anything else the Board of Inland Revenue would like to say?
There is a deadline for the provision of the information with respect to the Global Forum. I think it's September 2019. So I just want to say it's important that the bill is passed as soon as possible.
Well, that is the full operationalization, just like FATCA.
That's
where
correct.
we had deadlines to pass legislation, deadlines to draft guidelines, and deadlines to put it into operation. That's an operational guideline. So there's a lot of lead time to get to that point. For example, if we pass the legislation now, it will probably take about 9 to 10 months before we would be ready to share the information with the Global Forum countries.
Right, but of course we have some administrative work to do. So
and the deadlines that we are aware of this week. That's our
No, I know,
headlines.
I understand that, but I'm just...
Our
No, I know,
headlines.
I understand that, but I'm just...
Where did you
right.
get that September 2019 from?
The Global Forum.
It's the CRS
It's
standard
the-
she's referring to,
That's
Mr.
correct, yes,
Chairman,
the CRS,
which
yes,
is the
yes.
which is the automatic exchange
That's
of
correct,
information,
that's
which
correct.
is the replication of FATCA. It's just FATCA times 13
That's
countries.
correct.
So what it is that thing is the system is actually in effect.
Yes.
And the information is being shared.
Yes.
Right.
Yeah, so that we're
And that would-
automatically
And that would
exchanging.
take quite some time to get.
Correct. So that's 13 versions of FATCA, which is why we have been so adamant for the last 2 years to warn of the need for this. So, Madam Chair, if I could ask a question. So I take it that you are entirely happy from a legal point of view, through Ms. Aziz, with all of the clauses in the bill which replicate FATCA. That is clauses 6, 7, 8, 9, 10. Right? Because those are FATCA replicants. That's the allow you to process, receive, and exchange, right?
Right.
You've commented on the contentment of the BIR to have a judge deal with disclosure.
Yes.
And the first 4 clauses of the bill, which are long title, this act means Income Tax Act, proclamation, you're fine with that as well?
Yeah, we're
so
fine with that.
effectively then, is it correct to say that there are no other concerns on the bill?
No. With that? Okay. Anyway. Huh? Yeah, I would say so. I'll just let her speak. She has a little thing.
We did review the bill, AG, and besides that one concern we have, everything else appears to be in order for us.
Appreciate
Well,
it.
I was involved in the drafting as well, so...
Oh, that's good to know.
Thank you very much. Pleasure. Oh, I'm so sorry. It's catching my eyes.
Just to the benefit of the population, how pervasive is tax avoidance and tax evasion?
I will say now, there are many theories on how vast it is. There's currently an IMF person in Trinidad doing what we call the VAT gap. So we are trying to determine how large the gap, what you call the tax gap.
Have we any indication of how large it is?
Well, I know studies have been done. I know one was done by Professor Theodore. So he suggested a particular gap.
What is that gap?
I can't recall at this point in time, but I didn't agree with it. I'll say that. I don't know if I can say that, but...
I recall it. It's in the several billions of dollars
Yes.
of Trinidad and Tobago currency.
That's correct. But
I'm not sure if the study addressed it. In terms of tax evasion, who is more likely to evade taxes? What category? Is it the wealthy companies? Is it the average man in the streets? The middle class persons? Who?
everyone, once you give them the opportunity, they will. So what we do is we collect information and we use that information. And from looking at that information and comparing it, of course, to the returns that are being filed, yes, we see it. But we have information and we go after the...
But Madam Chair, isn't it true to say that the vast majority of people who are paying taxes by PAYE, pay as you earn, that is literally the entire public service of Trinidad and Tobago, for instance, that they would have a very difficult time in tax evading because their employers do the deductions automatically?
Yeah, well, before employment income,
So if that's
yes,
the case,
we
that
have
the
a
vast
safeguard there.
majority of the working population who has PAYEs on the track, wouldn't it be equally true to say that it is the people that are self-reporting, self-employed, or declaring by themselves in a higher income tax bracket than being employed that are really the people at risk?
They are the persons, but employed persons are also self-employed. There are many people who have their own business. So
I agree. They have a second form of income.
that's correct. Yeah, so we are aware of that too.
As well as the companies who are able to afford high-priced lawyers and accountants to do the evading.
You're telling me that, right? You're telling me that.
All right, Lynn.
Okay, noted.
So back to let me just touch on the production order. I have read and I have heard that, well, I know that business in this globalized economy, in this globalized space, are very mobile. And I've heard that some Eastern Europeans may come to Trinidad, set up business quickly, and then abscond. without paying taxes, and the businesses may be illegal. So wouldn't you agree that the new section 4, subsection 6, where you have production of the information, the taxpayer information, provided much quicker to the police and to the FIU, wouldn't that be a benefit to our governance systems, our tax administration, our ability to detect crime and the proceeds from crime, etc.?
Well, for the tax department, the information is for tax purposes. With respect to the police, that will be for, if they get it faster, well, I guess.
Would benefit.
It will benefit the crime situation, yes. Mm-hmm.
Thank you very much. BIR or IRD. What do you prefer to be called? IRD? We are live. Thank you very much, representatives of the Inland Revenue Division. Thank you. Okay, thank you. We're back with the live session of the Special Select Committee of the House of Representatives examining the Income Tax Amendment Bill 2018. And we have with us Ms. Savitri Sipasad, Deputy Permanent Secretary, Ministry of Finance. Ms. Sipasad, could you just give us an understanding of your role with respect to the discussions and the meetings and other interface with the Global Forum and EU?
Yes. Good afternoon, Chair and members. My role with respect to the Global Forums, I'll be very specific to the Global Forum. I represent the Ministry of Finance and Trinidad and Tobago on all matters relating to the Global Forum, as well as all matters that will relate to our obligations to the Global Forum requirements, our EU requirements, as well as our recent BEPS inclusive framework, because we recently joined the BEPS inclusive framework, where there's some correlation with the other two. And those responsibilities fall within my purview. I am responsible for coordinating all the activities to ensure and try to get Trinidad and Tobago compliant with these particular organizations.
And in so doing, in fulfilling this mandate, you have traveled to other countries to attend meetings relating to the Global Forum requirements for Trinidad and Tobago.
Yes, very specific. I would have attended meetings training actually for our fast track for the Global Forum, as well as I would have attended the last 2 plenaries of the Global Forum. There's an annual plenary for all Global Forum members. Actually, I recently came back from Uruguay. Yes, the last forum took place in Uruguay last week.
Can you tell us whether Trinidad and Tobago attempted to sign on to what is known as the MAC? Could you tell us what the acronym MAC means?
The MAC is actually a convention, is a Mutual Administrative Assistance Convention on tax matters. Now, just to give you an idea of what the MAC is all about. Now, I will step back a little if it's okay with the members.
Please, please.
The Global Forum, Trinidad and Tobago, is currently the only country that is non-compliant with the Global Forum based on our first round peer review.
How many other countries are there?
The Global Forum currently consists of 154 jurisdictions.
And we are the only
and
one
we are the only one that would have been reviewed on the first round and deemed non-compliant. At present, we are undergoing our second round review. So for the first round review, the major issues that we have as far as deficiencies would be being able to exchange information, which is where the income tax amendment bill comes in, as well as being able to exchange with a number of jurisdictions, and that is where the MAC comes in. So I could just speak to both of them. So it's Mutual Administrative Assistance in Tax Matters Convention.
Fine.
Yeah,
and that would
it's a
include
convention.
Sharing of tax information between our Inland Revenue Division and their counterpart tax authorities in these other countries.
Correct. So any member who has already joined the MAC, and at present, I believe there are over 85 jurisdictions that have joined the MAC, we will be able to immediately exchange that information and they share with us.
Fine. So once we sign, are allowed to sign, accede to the convention, the Mutual Assistance in Tax Matters Convention, we would immediately get access to 85 countries with respect to sharing of tax information.
Yes.
And that will go a long way towards making us compliant.
That is certainly going to help with respect to one of the recommendations that was made, that we were not able to exchange information with jurisdictions.
I understand Trinidad and Tobago attempted through the fast track process to accede or sign the Mutual Assistance Convention, and we were not allowed to. Could you elaborate on this?
So there are 2 things. With respect to the fast track process, because Trinidad and Tobago did not do anything since our review in 2011 to about 2015-16 when we really started to get some work done, we were recommended among some other countries to attempt a fast track process, really to see whether we did any sort of progress over that period in time. So we attempted the process. At the end of it, we remained in the same position, literally. In fact, I think although we remained non-compliant, the shortcomings appeared to be a little more than it was in 2011.
Fine.
So yes.
Is it true to say that if we don't pass this income tax amendment bill, we would not be allowed to sign this convention?
That is correct.
So this is a prerequisite to the convention.
It is.
And the convention is incorporated into one of the pieces of legislation that were before the Parliament previously. But we must pass the income tax amendment bill first, remove the secrecy provisions, and then we will be allowed to go to the next stage, which is the signing of the Mutual Assistance Convention in Tax Matters.
That's correct, because when we did request to become party to the MAC, we were told that there were issues with our competent authority not being able to obtain and share information. And of course, it's the income tax amendment.
So you were told that because the Inland Revenue Division of Trinidad and Tobago is unable to share information in the manner required by Global Forum, they would not allow us to become a member.
To become party to the MAC,
party
yes.
to the Mutual Assistance Convention. Okay. Any members have any questions? Okay. Thank you very much, Ms. Sipasad. This public hearing is now suspended. Thank you very much.